All right, ladies and gentlemen, we are live. Your corporation's committee is taking action today. Welcome, everyone. Let's go ahead and take the roll.
Representative Chadwick. Here. Representative Harrelson.
Here.
Representative Harshman.
Excused.
Vice Chairman Knapp.
Excused.
He went for lunch, though.
Yep, just mark them as excused until they
Okay.
cast a vote, then it should
All right.
register as a
Representative Newsom, excused. Representative Ottman.
excused. Oh, here's Representative Knapp. Say here.
Representative Knapp.
Say here.
Here. I said stay here.
Representative Wiley.
Here.
Thank you. Representative Yin.
Here.
Chairman Olson.
Here.
Thank you.
Apparently I can't compete because there's steak in the room down the hall, and
The whole room will
so
get up and leave now.
corporations bills, steak. All right, we're gonna take the bills just slightly out of order. We're here until 2:15 today. I believe that was the time that we would come back in. So I'm just trying to prioritize the bills in terms of easier to more difficult in order to maximize our time. The first bill that we will take up is House Bill 86, Disclosure of Private Cryptographic Keys. So committee, this bill comes to you from your Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology. This bill is not new to the Wyoming Legislature. It has been worked over the interim. It's an interim bill by the Select Committee. It has also been worked through previous sessions. So maybe we finally got this bill to a place where we can agree on it and advance it. What this bill does is it prohibits the compelled production of a private key that relates to a digital asset in both a criminal proceeding and in a civil proceeding. In essence, that's what it does. So let me back up and just describe to you what the private key is and why this is important. It's a little different than thinking about a key to your house, committee, because a key to your house, if somebody possesses the key, they don't actually possess your house. They just possess access to it. They can rekey. You can rekey the door if somebody had your key, no problem. When we're talking about a digital asset, there's only one key. That's the private key. You can't get a new key. You can't rekey. It's it. So the way to think about the digital asset, one way a lot of scholars do think about it is that the private key is actually the asset. Because if you control the private key, you control the asset. So if the key were, for example, handed over to a judge, the state of Wyoming would actually be in control of the asset. So that's what this bill is trying to do, is separate the information that's still discoverable from the asset itself. So I'll give you an example. If you're in a divorce proceeding and one party wants to know what the other party possesses in terms of assets, that is required. It's called a Rule 26 disclosure. So that's required by law that each party disclose all of their assets to each other. So this bill isn't going to stop that process. You would still have to say, I have 47 Bitcoin as an example, or I have $1,000 in my checking account at Wells Fargo, and I have $500 in my checking account at First Interstate Bank, and I have those 47 Bitcoins and 2 Ethereum coins. So that would be your disclosure. Now, in the divorce proceeding, the judge still has the authority to decide how to divvy up those assets, can still award a portion of those digital assets to the other party, in which case would require you to relinquish the asset. But what you can't ask for under this bill in discovery is the keys to the asset. And it's just as simple as that. Representative Yin, I know you're on the Select Committee on Blockchain, Financial Technology, and Digital Innovation. I don't know if you wanted to add anything.
Mr. Chairman, thank you. No, and the only thing, I guess the only thing I would really add is that we do have the definition of private key, and that's what the repealer is. The repealer is actually just moving it from the section where we've used it before in our blockchain statutes to move it to a more general definition area that we use in both this new section as well as our previous area.
Okay, and committee, I'll turn you, if you look, I should have done this, I'm sorry, in my presentation of the bill, but if you look at page 2, about the middle of the page, subsection B, lines 8 through 16, this was basically the last little bit of my conversation with you about the asset itself still being both discoverable and producible by order. So it says this section shall not be interpreted to prohibit any lawful proceeding that compels a person to produce, sell, transfer, convey, or otherwise disclose a digital asset. So again, the asset itself is still transferable by order of the court. If the court says, hey, I'm awarding it to this party, then they're awarding it to that party. If somebody stole a digital asset, criminally, they were charged. And if they were found guilty, the judge certainly could order that the asset be turned over. So that doesn't change either in a criminal proceeding. Just the keys to it would be the part that's not orderable by a court. Okay, so I just wanted to show you that meat in the bill. Questions, committee, on this bill? For me, it feels awkward. Yes, Representative Ottman.
Thank you, Mr. Chairman. You know my limited scope of experience with this. So I will just say, it looks as though everything is in order as far as making it discoverable and compelling and stuff. But me as an owner of this key, how am I protected?
Well, currently, without this statute, there's an argument that your key might not be protected, that you could potentially be ordered to hand over your key. And that's a really great question. You know, if you've ever read stories about somebody losing their keys, this has happened. People have lost literally millions of dollars in currency because once the key is lost, there's no third party you can go to regenerate a key. It's private. It's like a password that you simply can't change. So right now, arguably, if a court wanted to, it could require a party to turn over the key. It would probably only do that because the court doesn't have a full understanding of what the keys are. That's the purpose of this bill, is to clarify it in Wyoming law so that we know that, hey, the asset can be turned over, but not the key. I don't know if that helps, Representative Ottman.
Follow up,
Yeah.
please? Okay, that does make sense, but in layman's terms, so I want to go and I want to get a key. What does that mean? I mean, what is
Chairman.
it locking up?
Sure.
Thank you.
Representative Yin.
So, Mr. Chairman, so it's a piece of information. So let's do a more concrete example. Let's say you have a safe, right? It's a combination lock safe. So the key to your safe, it's not a physical key, it's just the combination, which is a set of numbers that accesses that safe. So with the digital asset space, it's similar, where a cryptographic key in a manner can unlock another piece of information online that's locked in a more virtual safe.
And Representative Yin, I would take the example one step further and say, now imagine that you have that safe with a combo, but you can never change the combo again in your life. You had one shot to set the combo, and when it was randomly set for you when you bought the safe, it came with the combo, and that combo, if you wrote it down and then you lost the piece of paper, you never get your safe open again because there's no third party that can come with a combo to open it.
I have one more follow-up.
Yeah.
Thank you, committee and everybody, for your patience. But who is it? Would it be me as a lay person, or who is it that's going to be having this information that's locked up? Thank
you. Thank you. I'll take a stab at that, and then I know Representative Yin wants to. Well, it would be you. If you owned assets digitally, you have a key that provides access to those assets. So you would be the holder of it. I suppose you could entrust a third party. You could entrust a trust company, or that's what the special purpose depository institutions, the speedy banks. These are banks that are designed as fiduciaries to hold possession of your key so you don't lose it. So there are third-party entities out there that could potentially hold the key. And this would say the same thing, that if a court, if for whatever reason a party wanted the key and they subpoenaed that third party who was holding your key, this order would prohibit that disclosure of the key itself. Representative Yin, good? Okay. All right, go to the public. Public testimony in this room on House Bill 86. Yep, Mr. Meyer, and then come on up, we'll get you. Representative Locke as well. Come on up, Mr. Meyer, just come on up. We won't confuse that the two of you are testifying together. Go ahead, Representative Locke.
Thank you, Mr. Chairman. I won't take much time. I just wanted to say that if I understand this correctly, so they can compel you to release the asset, but not compel you to release the encryption, the key. Okay, very good. I just wanted to make sure I absolutely understood. I'm sorry I missed the first part of the meeting, but
Oh, yeah.
I just wanted to say that just very quickly, from my perspective, this is a very critical component of privacy. It's very critical. And so I, of course, give a strong yes on this bill to protect the privacy of the individual and keep government out of those kinds of things. Because I'm not telling you anything, people here, you need to know, but obviously, once the key's released, your control over your asset is gone. Thank you.
Thank you, Representative Locke. I appreciate you touching on the piece of privacy and limiting government, because that really is the idea of the bill. You hit it home. Thank you. Questions for Representative Locke? All right. Thank you, Mr. Meyer.
Thank you, Mr. Chairman. Scott Meyer, Wyoming Bankers Association, and representing also my law firm, Scott W. Meyer, PC. Mr. Chairman, I think the only question that we have, and I'm sure that this is something you guys have thought about, but in those situations where you have a decedent that has a key and we don't know what's in it, so we don't know what's going to be distributed or how it's going to be distributed or anything else. Is there any provision that you can think of that would that maybe that key can be compelled by somebody or somehow, just so that you could administer a decedent's estate?
Mr. Meyer, I would suspect that it would be treated, I would liken it to a bank account similarly. If somebody wanted to know what was in the bank account, they knew that there was a bank account, they figured out it was a Wells Fargo bank account that the decedent owned, but they don't know how much is in it. They run into a problem where until they have letters testamentary or an order appointing them, that the bank is not going to talk to them. So in that scenario, if they want to know what's in the bank account, they have to go through, get the letters testamentary, and say, hey, here's what's in the bank account. Maybe they worked it privately and figured out what was in the bank account either way. If they happen to have the actual keys, if somebody has the keys, this wouldn't prohibit a personal representative from using the key to look and see what's in it. I think what would be a more likely scenario would be decedent passes away, has the private keys. We know what the private keys are. We don't know what asset is behind it. There's an open probate, and one of the potential heirs enters the probate and says, hey, I want to know what's behind that private key. And as you know, an inventory is required in a court supervised administration. So in the inventory, they're going to have to list what the asset is. If they don't know how to use the private key, they'll probably use a third party to help them understand how to use the key to figure out what the asset is. So, and if they didn't, I'm confident that a court would say, you need to file a proper inventory that says what is the asset. Just the same as if you listed gun safe, I'm sure an heir could show up and say, okay, it says gun safe, but what's in the gun safe? We want to know what's in the gun safe. And they'd have to say, here's what's in the gun safe, but they don't have to give the combo to the judge or to the heir. They don't have to give the combo to the heir. In fact, actually, I've dealt with that on safes before in my practice, where heirs want to know what's in a safe and you agree that everyone can come in the room together, you all agree to be there, all the parties are there when you open the safe, so that, you know, something like that can still occur with the cryptographic key where everyone can be present to see what the asset is without actually handing the keys to somebody else.
Well, Mr. Chairman, I guess my question is, what about the existence of a key to start with?
That'd be the same problem, Mr. Meyer, I know you probably run into as I do, when a potential personal representative calls and says, my dad passed away, and you're going through the list trying to figure out, do they own a house? Do they own a car? Do they have a retirement? Do they have bank accounts? I have no idea. I don't know. I don't know if they have bank accounts. I mean, we run into that scenario already. So I don't think the bill really touches on that. I think ultimately the way I think courts will still have in-betweens. You know, there's nothing that is going to prohibit a court from having like an in-camera review or something like that. It's just turning over the asset is the key to the bill. But there's no real, I haven't really thought through any scenario in the probate world that I wouldn't be treated any differently than other assets, at least from my perspective.
Thank you, Mr. Chairman. That's all I had. I'll stand for any questions.
Okay. Questions for Mr. Meyer? All right, now you got me thinking. Appreciate
Thank you,
that.
sir.
Additional public testimony in the room. Additional public testimony in the room. Let's look at our online. I see a lot of 49s. Does anybody in the digital world like to testify on this digital bill? House Bill 86. Nope, then I will close public comment on this bill. Committee, what is your pleasure? And moved by Representative Ottman and seconded by Representative Chadwick. Okay, amendments on this bill. Amendments to page 1, page 2, page 3. Discussion on this bill. You ready to vote on this bill? All right, Barb, will you please do a roll call vote on House Bill 86, disclosure of private cryptographic keys?
Representative Chadwick? Aye. Representative Haroldson? Aye. Representative Harshman? Oh,
Barb, you have his vote.
I do have his vote. Yes, by absentee. Vice Chairman Knapp?
Aye.
Representative Newsom, she's online.
Is she really? Is it possible to let,
She's in the room.
you want to let her in?
I did. She is, so.
Representative Newsom, can you hear us? Okay, well, leave her in the room,
Okay, well.
but I'll leave her as excused.
Thank you. Representative Ottman?
Aye.
Representative Wiley?
Aye.
Representative Yin?
Aye.
Chairman Olson?
Aye.
8 aye, 1 excused.
All right, next bill for our consideration is House Bill 49, Municipal Nonpartisan Rank Choice Elections. Representative Zwanitzer was here.
He had to run. He'll be back.
He'll be back.
That's what he said.
Okay. Well, I was relying on him to introduce this bill to us. Yeah, let's give, give Representative Yin a chance to maybe find him
Take a couple bites.
before we move to House Bill 63. Sorry, public, if you're here for House, I know there's a lot of folks here for House Bill 49, and I know in the virtual world, I've got quite a few people signed up for House Bill 49. We just need this is an interim bill, so it was built during the interim bill, the same as everybody else, but I really don't have the background to introduce it. So we'll give him just a minute before we go to House Bill 63. Okay. It looks like maybe he'll be a few minutes away. So let's go to House Bill 63 and then we'll circle back to 49. House Bill 63, Committee Vacancies in Elected Office. This is also an interim bill. It was prepared over the interim session by your Joint Corporations, Elections, and Political Subdivisions Interim Committee. This bill requires special elections if more than half of the term of an office remains. And right now, that statute already applies to the governor and U.S. Congress. So if you're in U.S. Congress or you're the governor and you vacate your office, you resign from your office, and you have more than half of your term remaining, it goes to a special election. What this bill does is add to that the United States Senate. We're gonna do the same system we've always done for U.S. Congress and governor, but we're gonna do it for the U.S. Senate. It adds the other 4 statewide elected offices, so the superintendent of public instruction, the auditor, the treasurer, and the secretary of state. And then it adds us, legislators, the representatives and senators to this list as well. So if more than half of the term is remaining for any of those elected offices, then a special election is held to fill the vacancy. If the opposite is true, if you have less than half of your time remaining and you are one of those elected officials, then it follows the current vacancy process, which requires, if you're a legislator, for example, your local precincts, central committee, men and women, the precincts within your House seat, to select 3 names and submit them to the governor. If you are a statewide elected official, that existing process would be through the Wyoming State Republican Party or Democratic Party, depending on the party affiliation of the person vacating their office. And that committee of that party, that state committee, would select 3 names and submit them to the governor. Representative Chadwick.
Pardon me, Mr. Chairman, but I do believe that after the 3 names are chosen by the precinct committee people, those 3 names go to the county commissioners.
Thank you for correcting me. You are 100% correct. They do go to the commissioners. So I apologize for that. So for legislators, it goes to the commissioners. For the statewide elected Congress and U.S. Senate, it goes to the governor. So that's the bill. Don't ask me any questions about it because that's all I know about it. Secretary of State Gray, would you like to come on up and comment on this bill? Welcome.
Thank you. Thank you, Mr. Chairman. May I go ahead?
Please.
I'm Chuck Gray, Wyoming Secretary of State. To my right is Jesse Naiman, our Chief Deputy, and to the left is Joe Rubino, our Chief Policy Director and also the General Counsel for the office. On House Bill 63, I mean, we're going to implement whatever the legislature puts before us. But we are opposing this one. The current system that Wyoming uses for filling vacancies is a good one. Allows the party central committee for the party of the prior office holder to screen candidates and select 3 candidates to forward to the governor or commissioners in the case of a legislative vacancy, and then requires the governor or commissioners to select 1 candidate to fill the seat. This system ensures that duly elected party representatives can choose nominees to fill the seat with candidates who share that party's values. It's almost like a primary. This system has worked for years, and I do not think it should be disturbed. The proposed special election system in HB 63 creates a free-for-all election to be held within 110 days of the vacancy. It allows for any person of any party to declare and run for the seat and provides that the winner of the election only needs a plurality of the vote to win. This could create bizarre election outcomes that do not reflect the will of the people. For example, you could have a situation where the majority party fields, say, 8 candidates and the minority party fields 1 or 2, and you're going to have bizarre outcomes in that jungle situation, potentially. Also, this process would favor candidates with the monetary resources to mobilize a campaign in short order in a way in which our traditional system does not. The other thing I would note is that it lengthens the period of time in which a vacancy would be vacant, which in these legislative seats, I mean, if you have a vacancy created a week or two before the session, that representation is going to be lost. Finally, the cost of running a special election should be considered. Previous estimates indicate that special election costs for a statewide could cost about $1 million per election. I would note as well that the current vacancy process has produced winners from across the spectrum ideologically. We can talk about that more in the Q&A or when you debate the bill. For these reasons, I ask the committee to vote no on House Bill 63, but certainly we're going to implement whatever's brought forward. So
Glad to hear that.
yes,
Good. Representative, man, I am so sorry.
it's okay.
Secretary
I miss
Gray.
it too. You miss
I-
me in that
For
position.
those in the public who don't know this, Representative Gray and I came into the House at the exact same time. So I served 6 years with him and called him
Yes.
representative. So I am still getting used to it. Secretary Gray. So the cost, you said the cost of running a special election could cost upwards of 1 million. Do you have the breakdown of what a cost is what was the cost for the last general election?
Yeah, Jesse did the breakdown on that. Mr. Naaman.
Deputy Naaman?
Yep.
Mr. Chairman, if I may, the way I came up with that number is the Secretary of State's office had conducted a fiscal note in 2022 for the runoff bill. If you factor in a runoff election, as was proposed in 2022, would be statewide. This would similarly be a statewide affair. That is how we came up with that number. Thank you.
So what is the exact number?
The number we gave in that runoff, I believe the estimate was 1.1 million in that fiscal note, but I don't have a precise number for this committee today.
Okay. So has your office, that currently for governor, if more than half of the terms remaining or the governor vacates his office, it's a special election. Is your office familiar with have we ever had a special election for governor in Wyoming?
Mr. Chairman, interesting question. We can certainly do the research on that. I wouldn't want to comment before doing that. Not in my recollection.
Yeah, not in mine either.
Yes.
But it'd be pretty far back, so comparing the dollars wouldn't probably be very helpful for us. I'm trying to figure out how we can compare those dollars a little more, but if it's not in recent history with inflation and cost adjustment, then the dollars probably aren't going to be that helpful. But yeah, I'd love to know if your office has that information. Representative Chadwick?
Thank you, Mr. Chairman. To the notion that these special elections could create chaos, basically, do you have any kind of numbers for the turnout that you get in special elections? Because I imagine it's pretty poor.
Thank you.
Secretary Gray.
Thank you, Chairman, Mr. Chairman, and Representative Chadwick. It is. We could pull that in other jurisdictions as well as examples here, but it gets very low. So I think that's a great point. I mean, is that truly the will of the voters?
Follow it?
Yes, please follow up.
So you're not really getting, you're getting this small group rather than the whole group typically in that
Yep.
setting. And thus, perhaps chaos. Okay, thank you.
Mr. Chairman, Representative Chadwick, and then you add in the jungle aspect where everybody's going to be on the same ballot. It's one round. So say you have a vacancy for fill in any treasurer, you get 8 Republicans, 8 from the majority party, 1 from the minority party, plus you get this turnout factor. It just amplifies the chaos in my opinion. Thank you.
Secretary Gray, I have to push back a little bit on the comment that a special election would not reflect the will of the people. An election, by definition, is the will of the people. Whoever wins an election, whether it was your candidate or not, at least my understanding of that would be the will of the people. So can you elaborate on that deeper?
Thank you, Mr. Chairman. I think what we were comparing it to is to a normal election. and, having that normal process. What's that?
When you say normal election, are you talking about
A
a
general primary
elections,
process, a normal cycle.
One Republican, one Democrat, head to head.
That, the turnout factor, the chaos of the jungle aspect, the timing, the lack of notice, it being on a day totally separate from what we've become used to for decades, the third week of August, and obviously really since beginning of statehood on the November date. That was inculcated at the federal level quite some time ago. So, I mean, I just, you include all those factors. It was a comment reflecting the comparison to what a normal election cycle would be.
Committee, additional questions for Secretary Gray? Okay. All right, we appreciate.
Thank you.
We appreciate your testimony. Anyone in the room wishing to testify on House Bill 63? Come on up, our clerks. And there's no rush. You can have a seat at your pleasure and you'll come up. Yesterday was a little bit different with, 24 people wanting to testify. Just trying to keep it running, but today looks a little calmer. Welcome.
Mr. Chairman, I'm Mary Langford, and I have the honor of representing the county clerks. And at the table today with me are 2 county clerks. I have the Honorable Julie Fries from Fremont County and the Honorable Gwen Bartlett from Carbon County. And we would like to talk about the administration of this particular election issue. We have reviewed and been involved with the development, I believe, the schedule that is promoted in this particular piece of legislation, and that the elections that are intended here would fall on regular election days as opposed to being eligible for any Tuesday, any day, any month through the whole year. So to help take care of some of the costs so that it could run on a ballot that was already in process. The question that was brought up before about the cost of one of these elections, the statewide primary in 2020 was estimated to be $1.1 million. And that was done by the Clerks Association with information that was gathered from the counties. This bill includes payment for part of the election. If the election should fall on payment from the state to the counties to cover that cost, if the election should fall separate as a special election away from an election that's already concurrent. Typically with these elections, and remember, this is a pilot project, would be a municipality, so a town or a county, or I'm sorry, a town or a city. And those people have local option. Oh, that's right. Oh, I'm sorry. Sorry, wrong bill. We'll back up. 1.1 million is still good, though. Yeah. Yeah, they would fall on a regularly scheduled election. So the August primary, the general, Maytown, those dates, yeah. We've looked at the schedule. We also have the 45 days that we need to be able to do absentee voting during that time, which is required of those federal seats that could possibly be on that ballot. And let's see. Oh, right. And then the costs that we're talking about are not allowed at a primary or a general. So according to the, yeah. Okay. I'm going to hand off here because I'm not doing a very good job. I'm really sorry.
It's all right. Go ahead.
Julie Freeze, Fremont County Clerk, Mr. Chairman, members of the committee. So in this particular bill, it does say that we can be reimbursed for costs. That's only if it is a separate election, not if it falls onto one of our regular elections, which we do, excuse me, do go out and charge our other entities that are on our ballot. We have long talked about the state not having any costs in our election, but if you're throwing a separate part of the election on there, it doesn't say in this bill that we will get reimbursed for that. Also, because it does say that we will get reimbursed for costs, I think that you might want to throw in here that there should be some rules about what costs that we will get reimbursed. It does say that you'll work with the county treasurer, who's going to have to come to the county clerk and find out how much we spent on an election to be able to find out how much that is. And we want to be consistent. We're trying really hard in elections to be consistent and uniform across the state. So I think this is a good time to maybe put some rules, if you're going to pass this bill, to say what that is that you will reimburse to the counties.
Is there any way to put your thumb on the dollar amount of a legislative vacancy special election? So that's only going to occur if it were my seat that were vacated, there would be one election in Laramie County. If one of my counterparts, it might be 3 different counties. The 1.1 million for the 2020 primary is a statewide cost. I
Right.
don't imagine that breaks down perfectly equal between the 23 counties.
Mr. Chairman and members of the committee, so first you have to remember that putting on an election, the lion's share of your election doesn't change. You still have election judges, you still have polls open.
Ballots.
It's the ballot size. And so really the dollar amount's not going to be tremendously decreased because it still takes, a lion's share of that is just putting on an election, not just the ballot size.
In 23 counties though, but if there's only one county, if only Fremont County legislator was filling the vacancy, would it be a 1/23 of the cost?
So, Mr. Chairman, Gwen Bartlett, Carbon County Clerk. I don't have the data in front of me, but we do have a county by county cost that
Oh.
came from each county clerk that we could provide to the committee.
That'd be really
would
helpful.
like.
Okay, that would be very helpful.
And Mr. Chairman, there was, I think, a question you also asked if there had ever been, so when Dick Cheney became the vice president, we did have an election. I'm trying to think how many years ago that
Oh,
was,
to
around
fill that
14 years ago
representative
or whatever. We
seat.
did have a county or a statewide election to replace our US House person.
Okay. Representative Haroldson.
Thank you very much, Mr. Chairman. So, and I'll throw this out to whoever wants to take a whack at it. So we mentioned the 45-day window for absentee ballots. So let's just get an idea from, let's say that we had a vacancy open in one of these positions. We for sure are 45 days before we could see an election even take place, but it's probably even longer than that. If, in your opinion, your educated opinion, how long from a vacancy to having an individual filling that position and representing the people once again?
Yeah,
Yeah.
Mr. Chairman,
Please.
Representative Haroldson, I want to say Halderson, sorry. In a primary, it'd be at least 110 days because of the statutory timeline to publish the proclamation. Does that answer the question?
Follow up.
Please.
So in this case of a special election to fill a vacancy, 110 days is our bare minimum. So basically a
So, yes.
third of a year that we do not have representation as a governor, we would be riding on a Secretary of State at that point. We could have a US sitting senator or House member with no vote from the state of Wyoming. Am I reading this correctly? I just trying to figure that out.
But your math might be a little off. I don't know if it's a third. It's more like 25%.
I said almost 110 days,
90
365,
days is 3 months. I'm not gonna.
365. Is it? We're gonna go back to math, you guys. So
Neither one of
almost
us-
a third.
Neither one
I
of us
said.
are statisticians. You're a preacher and I'm a lawyer. We're way out of our league here. Okay, go ahead.
I'm not even sure where the question was.
Mr. Chairman, Mr. Chairman, Representative Haroldson. So when we first looked at this, I was concerned about the 45 days and made that notation to my representatives about that. But What I am happy about in this bill is that it does say that we can only have elections May and August and November, which are already set in statute. So we make sure we meet all that criteria. I like that. I don't really want to deviate from that because I am concerned that not only can I get absentee ballots out, can I do the rest of my job? Because after 2022, it is not that I'm going to say elections have ever been easy, but it was a very difficult time to get all of the things done we needed to this year. So if we are going to move towards something, we can administer this, it appears, as far as we can tell, unless something comes up that we can answer that says, no, we aren't going to be able to administer it. I know that seems like a long time. And I don't know if the issue is more that the public wants to be the one saying this is who should be in that seat because it's such a long period of time, or what brought this up there. So,
Representative Chadwick?
Thank you, Mr. Chairman. So, as I recall, currently, under current statute, what it takes about 2 weeks to get someone into that seat, as far as a representative, et cetera,
through appointment.
absent the federal seats. Is that pretty close to accurate? It's roughly 2 weeks from the time the resignation or whatever takes place.
Are you talking, Mr. Chairman?
Please.
Representative Chadwick, are you talking about appointment?
Yes.
Yes, the appointment process
Under
is
the current system.
approximately 20 days, maybe. I think it is 5 days for report, for it to get to the party, and then the party has so many days, 15 days, I believe, to get it to so about 20 days. So.
Representative Yin?
Thank you, Mr. Chairman. Clerk Freeze, Clerk Bartlett, thank you for joining us. In your historical memory, do you know what the longest period there was, what the shortest period after an election that someone created a vacancy in the office where it was filled? And so how long was that term where they filled a vacancy without being being elected by an election? If that makes sense. So I guess my question is, what is the longest term that you know of for someone who has filled a vacancy before having an election?
Mr. Chairman,
Yes.
Representative Ian, are you asking if a vacancy was, say, declared in May and filled, and then they filled the seat through December? Or maybe I guess we're still not understanding the question.
So, Mr. Chairman, thank you. My question is essentially, if someone was elected in November and then they decided they were moving 2 months later, and they created the vacancy, has there been a situation where almost a full term has been filled by someone who didn't win an election?
That's possible. Mr. Chairman, Representative Yen, so I can't give you a person specifically, but remember that the time frame to show up at election again, so to speak, is, so in that situation, if somebody was elected in November and then waited, till today and says, I can't be that person anymore, they would serve as an appointed position until 2024, when you have to be up on the ballot again. Does that maybe help answer that question, even though I don't have a person? Okay.
Sure. Thank you, Mr. Chairman. Yeah, I was just seeing if you had in your historical memory an example,
I'm
because
sure
I know
there
you
are.
all
Mr.
see a
Chairman.
lot.
Yeah, Vice Chairman Knapp.
I might be able to answer that. So my original term was due to the uneventful death of Roy Edwards. And so I filled his original term up to the election. He had actually won the election. And then I filled his election term of 2 years. So I served his first unended portion, a second full term of 2 years, and then was reelected. So that's one example, I guess I can give you.
Hopefully an occurrence that doesn't happen very often as a whole. Representative Chadwick.
Thank you, Mr. Chairman. And I can add a little bit to this because we had one in Natona County where in early November, we had an individual who was elected, and then I believe it was less than a month thereafter he resigned, and we as commissioners had to choose the replacement from the three that were provided to us from the party from which he was in. Now, and you guys, I hope, know more about this than I do, but as I recall, there are different time spans between notification and when that has to be referred to the commissioners by the party, and then the commissioners have X amount of time. And I know different positions have different timeframes. So it could be as short as a couple of weeks from the time the notification comes until their appointment. Could be 3 weeks, depending upon the position. And of course, commissioners have to replace county clerks, county assessors, you name it. We had to replace just about everybody at one time or another. So I know that that's a factor, but from my remembrance, 2 to 3 weeks covers currently about 95% of what we do currently.
Mr. Chairman?
Yes.
Commissioner, who used to be a commissioner, I apologize, Representative Chadwick. So I believe everybody has the same time frame. I know there has been a lot of discussion across the state, and as clerks, we've said, well, what are you doing? That's a little bit different. So the way the statute reads is once it is vacated. But I know there has been a lot of county attorney decisions on what is vacated. I told you I was going to be done. In our county, we have started doing it the minute they are out of the seat, then that is not when they're notified, it's when the seat is vacated, because that's the way they read the statute. So that might be what the difference is you're talking about, but I believe they all have the same time requirements of so many days to get to the party and so many days for the county commissioners to choose, or the governor or whatever, so I think.
Representative Ottman?
Yes, thank you, Mr. Chairman. Commissioners, Ms. Freeze, how are you? Okay, so there's an opening currently, vacation, long vacation. And so somebody is chosen by the party to which they come. And then it is 3 are given to the county commissioners or whomever is going to make that choice. So that is the way it works. And it seems to me as though it's working relatively well. But if it is changed to go along with this bill, what would that do? Because now we have people that it's advertised. I know your office has put that out. And also through the party and then through the commissioners or whoever the head of that is. But if we pass this bill, doesn't that or would that make it very, very difficult for people because they would be campaigning then for an election? And would that make it difficult to say it was the next election was going to be in 45 days or whatever? Would that, do you think, limit good candid campaigning?
If you
Thank you.
can answer that. It's not really a question for the clerks necessarily. It's a question and it's a good one. It's just whether the clerks have an opinion on campaigning or not. I don't know.
Mr. Chairman, I think it could be confusing for the public potentially. If I am already campaigning to fill a legislative seat and and I got past the primary, I'm on the general election, and then there is a vacancy in the seat that I'm trying to get elected to, that could also be on the same general election. I think in that scenario, it could be confusing and I could potentially be campaigning for both or one or the other. I don't know if it's up to us to say, to answer your direct question.
You
Mr.
did.
Chairman?
Yes.
I don't know that it actually answers that question, but now it brought me another question. So after Gwen just said that, so let's say I don't like the representative who runs, so in my primary, I run against them, and I am successful, they are still a representative, then they decide to quit. Now you potentially could have two of the same party in the general? I don't know. That could be a problem. I don't know if that's a problem or not. I just thought of that when she said that, so anyway.
That is helpful to think about problems with this bill.
Ms. Sherman, I just had one more comment. In Carbon County, in our last special election, we don't have very many. It was 2019, and it was a specific purpose tax election. So they're again not electing a person, but we had a 29% turnout. And I don't know how that compares to the rest of the state, but typically the turnout is lower for a special election.
Right. That is definitely true. All right. Thank you, clerks.
Thank you.
Go ahead, sir, and introduce yourself for the record and let us know what you want us to hear.
Good afternoon, Chairman Olson, representatives. My name is Steve Melia from Cheyenne, Wyoming here. I would urge you to keep the current system and not adopt this for several reasons. One, as the clerks had mentioned, that's going to be an awful lot of work for them to do all over again. Number two, as mentioned by Secretary of State Gray, there's people that have a lot of money out there, they can go back in and they can start campaigning a lot. I have worked several campaigns and I've put in a lot of money, which means that, well, I'm gonna have to go out and knock on another 1,000 doors. I've knocked on many doors before, and that's a lot of work. And I'm a Republican, and if a Republican was in that seat, I'd like to have them back in there. However, if a Democrat had been elected to that seat, I think it'd only be fair and right that another Democrat would fill that seat, rather than having them say, well, you got to do it all over again. So there's also that point of Representative Chadwick said, there's a small number of percentage of people that vote, then they're gonna have to come out and do it again. They may not even know that there's a special election. And so that misrepresentation, shall we say, would also be a factor. So, and I guess I don't really want to walk on another 1,000 doors, et cetera.
Committee questions? All right, we do appreciate your testimony. Thank you.
Thank you, Chairman Alston.
Just going down the line here. Ms. Simmons?
Gail Simmons, Civics 307. I am on and for this, and I have a recommended amendment. First of all, I would like to point out, this is the equivalent of a general election, not a primary. It's a general election. Everybody gets to vote because it is fulfilling an elected position. We don't elect people in the primary, we elect people in the general. I also want to point out that no matter what the turnout is on a special election, it's going to be higher, guaranteed, than the 100 that make a choice in a state central committee to give 3 names to the governor. So no matter how low the turnout is, it's going to be higher than the 100 at the state central committee or the maybe couple of hundred at a county central committee. So I don't think that that's a consideration. I would recommend that the candidates, and again, this is where it meets the criteria for a special election, that the candidates can only be those who are affiliated with the incumbent's political party at the time of notification of vacancy, unless independent, in which case it could be any. Because if a Democrat unfortunately dies, to the point made previously, it ought to be a Democrat who fills that. So I think that that was a miss in this, in that it should be required that the individuals who are put in for that special election be of the same political party as the incumbent who had left. I do want to say that I appreciate that the Secretary of State made the case against runoffs and also showing the benefits of having ranked choice voting. So on the amendment that I was looking at would simply be on pages 18 through 20, to, in effect, remove the jungle voting, basically. So on page 18, it would be lines 22 and 23 would be removed. On page 19, lines 1 through 10. On page 19, line 22, after the 122, it would be a period instead of a comma. Strike the rest of that line. Strike 23. And on the following page 20, lines 1 through 2, 1 and 2 would be struck. So in effect, what that does is it removes the jungle primary. Now, I don't have the amendment that would basically state, I don't know where the language, but it would need to put in there that the candidates would need to be affiliated with the party of the individual who created the vacancy. There is also at the end, there is of this bill, it allows for temporary, I can't find the page, but it basically putting in a temporary because of the time frame in order before you have an election. And in that case, I would recommend that there be a temporary appointment when it otherwise meets the criteria, so that the office is filled prior to that special election, and that go through the current process. So whatever the party is, it's state central committee or county central committee, the only provision I would have is the individual who is appointed cannot be an individual who is then campaigning or asking to be elected in a special. And that's because of the preference that is given to incumbents. So I would just put that provision in. But it's a good bill. It makes sense. It actually puts the decision-making back on the electorate. But I do agree that it should be filled with somebody from the same party unless they're independent, in which case it should be jungle. And I stand for questions.
Questions, committee? Representative Haroldson, your mic's on. Okay, thank you, Ms. Simons. Ms. Lone, welcome.
Chairman Olson and representatives, thank you for having me. My name is Susan Lone. I'm in House District 411. And I'm just speaking to you from a precinct's point of view. I'm a precinct committee person. I've been in since 2009. Since we've lived there, we have gone through 2 representatives that have had to step down. And we had to have an election. The first, the process is to submit your application. And then it was brought to the precinct people, and we were allowed to vote. And as precinct people, we were allowed to vote on 3 people that we submitted to the commissioners. And it worked very well. I don't see why we would change a system that's not broken. And those are just my comments, and it was kind of neat to, participate in that as a committee person. And to me, this looks like that would kind of do away with our positions also. So thank you.
Questions, committee, for Ms. Lone? All right, thank you for your testimony. Representative Slagle, welcome.
Thank you. Thank you, Chairman Olson and committee. Appreciate this opportunity to testify before you. I agree with the sentiments of the lady that just spoke before me. I wanted to say, I don't think the system is broken. I think it's functioning very well. And part of that is the way we pick our replacements. We got to remember we are representative government. And so our state committee men and committee women are elected representatives for the people from their precincts and their counties. And I think this system works well. And as has been mentioned earlier, These special elections cost a lot of money and delay the process a long time. I know just before I got elected, the representative from my district stepped down. And so then we had to choose a replacement for him. And it was only about 2 weeks, maybe 3 weeks before the special election or special session with COVID. And so it was a timely deal that had to be done quickly. And being in 3 counties, that makes that process even a little more difficult, but we were able to accomplish it in a timely manner and had my predecessor appointed before the special session began. I stand for any questions.
I do remember that appointment. I served with both of those representatives. All right, thank you, Representative Slagle.
Thank you.
Additional public testimony in the room? Additional public testimony in this room? You want 2 bites at this apple? I don't know. Okay. Welcome back, Secretary Gray.
Yeah, appreciate it, Mr. Chairman. Chairman, it's important to me that I think one of my roles on this is to make sure all the information's in front of you. Having been a former legislator, I know you got a lot coming at you, and I want to clarify on when these elections will be held, because I think on Ms. Langford's statement, I know there was a little confusion on the ranked choice statement there. I just want to clarify that 70% of the time, these elections would not be held on a normal election date. So, you think about the 2-year cycle, and this is for state rep. I mean, congressional, US Senate, the math's a little different, but the way the statute reads is if it's within 110 days of the primary or the general, it gets subsumed in that election ballot. So, I mean, that's 220 days across the 2-year cycle. That's about 30% of the time. Otherwise, it would be subsumed in the next election, which are the bond elections that are laid out in statute, which are very rare, probably unlikely that there would be anything else on that ballot. And that's either the first Tuesday after the first Monday in May or November, or the first Tuesday after the third Monday in August. So you'd basically be in 5 bands every 2 years, at least on state rep. Would either be on the primary, the general, or on these bond election dates in the off year, which are set out as possibly being done in May, probably the second week of May, the second week of August, or the third week, or the first week of November. That's kind of the way it would work. You'd be in 5 different zones, and 70% of the time, unless there was a bond election already cited, which is pretty unlikely, it would be on a ballot on its own. That's the way I read it. So, thanks. And Mr.
3
Chairman,
bites at the
yeah,
apple.
well, the one other thing is, I would ask the committee, it says the secretary is to reimburse the counties for these elections. And, I could tell you, I mean, I would like some clarification on exactly what the procedure would be there. I mean, on a legislative one, we could probably absorb it till the next budget session or supplemental, but on a statewide one, $1 million, I'm not sure how we do that. So.
It's a great question on the, the 1.1. I would think there is no appropriation in this bill, but also from the testimony that at least we heard from the clerk's office, these elections have been far and few between. I still would like to know what that's the statewide cost is the 1.1. I still think the legislative race could be somewhere in the tens of thousands of dollars, I would assume. So it'd be a little easier to consume it. Maybe we need a special election fund, emergency fund. And the governor would have B11 authority as well. So there's that, I suppose. All right, additional public testimony on this bill. Public testimony online? How many? 1, let them on in. If you would like to testify on this bill and you're in the virtual world, raise your hand so we can bring you into the room. Welcome.
Mr. Chairman, can you hear me?
We sure can.
Yes, well, thank you for the opportunity to join you and to speak with you over Zoom. My name is Brett Glass. I'm in Laramie, Wyoming, where we've actually had some situations where we've had to replace officials who have stepped down or have otherwise left office. And my concern is simply for democracy. We're a democratic republic, and more democracy is always better. In my personal opinion, and the opinion of many people I know, we should, if at all possible, avoid having the party bosses pick office holders in a back room, because history has shown that they make decisions based on party loyalty, not necessarily the public's best interests. And once they pick someone, that person has the major advantages of incumbency when the next election comes around. So I would say that we absolutely need to have elections. I would even lower the threshold. I would even recommend that if 25% of the term was left, we should consider having an election. As for the issue of having a jungle election, perhaps this is a time to consider, as we're going to discuss when we consider the next bill today, having instant runoff or ranked choice voting. That would eliminate any problems associated with that. And finally, as for the cost, you can't put a price on democracy. No amount is too much. And I think if we need to appropriate the funds or have a special fund, we should do it. But we should make sure that the people always have a choice, and that and the person who represents us, again, isn't chosen in some smoke-filled back room or in a partisan beauty contest, but is someone who really represents us. That's all I have to say. Thank you for your time.
Thank you, Mr. Glass, for joining us and for your comments. Committee, questions for Mr. Glass? All right. Again, we appreciate you joining us and giving us your testimony. Any additional public testimony? Okay, I will close public testimony on this bill. Committee, what is your pleasure? Moved by Representative Harshman, seconded by Representative Yin. I am not going to flip through 26 pages asking you if you have amendments on each page, but I will ask you if you do have amendments.
Mr. Chairman, I have an amendment.
Representative Yin.
Mr. Chairman, I move that we amend page 13, line 14, where it says an elector qualified to hold a vacated office. After the word qualified, add, I'll go very slowly, in the same political party as the last incumbent at the time of their last election, unless the incumbent was an independent.
The same political party as the last incumbent.
Unless the incumbent was independent. And I also add the clause of at the time of their last election, because that's the existing language we have now for who gets to appoint, right? So if someone switched parties and then resigned, that doesn't change what party would go on the ballot.
Do we have a second on this amendment? Seconded. It's been seconded for discussion. Okay, what are you doing here, Representative Yin?
Mr. Chairman, so I think this actually fulfills the intent of Ms. Simmons' amendment without removing all of the jungle stuff, because that is necessary if it is an independent who resigns, right? So all of that stuff does need to happen. This still just makes it so it's only one party who can run if the vacancy is in place. So only electors within that party are
So if I understand
eligible.
your amendment right, this, if it were a Republican who resigned, then we would have only one Republican? Or would it be only Republicans?
Only Republicans,
Okay.
Mr. Chairman, thank you, would be eligible to register to be put on the ballot.
So we could have 1, 10, 20 Republicans, but we
Correct.
could not have a member of the other parties or an
Or
independent?
independents, that is correct.
Okay, so additional discussion on this amendment? This
Mr.
is a good
Chairman,
amendment. Yep,
who seconded that?
seconded by Representative Harshman.
Thank you.
Ready for the question on the amendment? All those in favor signify by saying aye. Those opposed? That amendment has been adopted. Back on the bill. Additional amendments to this bill? Any discussion on this bill? Representative Harshman.
Mr. Chairman, this is similar to a bill, a personal bill I ran, I think a year ago or 2 years ago. Is a year ago, I guess, when we had the 2/3 threshold to introduce a bill, had 39 votes, one short. And of course, that 2/3 mandate, as many as you know, was not in our original constitution. That was added in the 70s. But my point in bringing that bill then was really to return us to the way we were at the beginning of statehood, when we did have special elections. And that's how we had the first woman governor, right? It was because of special election. And we still do special elections for governor and US Congress. I think with this 17th Amendment, I think obviously changed things for the US Senate. I think we should deal with it. And the legislature was always special election for a vacancy from 1890 till basically 1950. So the first half of statehood, and was changed then. And I think now, more than ever, it's easier to communicate and all that. I think it's important to let the people elect their representatives. So that's why I've been a proponent of this bill. And then I just think too, there's, you know, our statewide offices. Before this last election cycle, of the 5 statewide, we had 4 that were initially appointed to their first term in office or subsequently appointed. 4 out of the 5 were appointed. And I thought, I don't know, at what point do the people get elected their people? And so I just think, you know, and that was probably you know, an extreme point maybe in our history. But I just think it's important now, and it's probably easier than ever to run these elections now. And so that's why I've been supportive. Thank you, Mr. Chairman.
Thank you, Representative Harshman, Vice Chairman Knapp, and then Representative Ottman.
Mr. Chairman, I have a problem with the bill in a couple regards. One is I don't define a special election when it has to fall in May, August, or November. And the second thing is the representation of the people. So a time factor is important. If you can appoint somebody within a 20-day period to both hit interim topics for legislation and potentially to even fill a seat in a session versus 110 days of doing that, I think that's important that our counties have, or our districts have, that representation available to them instead of potentially not filling a seat in session. So that's my comments.
Representative Ottman.
Thank you, Mr. Chairman. I would also just, as an addition to that, remember that in an election, of course, the voters do vote. Voter turnout isn't all that high, but the process that we use through the precinct committee people and everything is also representation of the people of the precincts and the state. So, thank you.
Mr. Chairman, I just had a question
Representative
on
Harshman.
that night when there was a witness speaking too, and maybe somebody knows this, but how many precinct people are, you know, many of them are elected, but many of them are appointed. And there's got to be a number on that, on the percent of precinct people that are appointed. And so, I mean, you know, you can take, so anyway, as a question, I thought, I don't know the answer, I have no idea.
Well, I
but
think it's a really good question. I know in my local central committee, every central committee meeting, virtually every meeting, there are appointments that we make to fill vacancies because vacancies are always occurring. People resign, people move. Last night, my central committee met and appointed, I think, about 12, a dozen new members got appointed, and that's not terribly unusual for my county, which has just under 200 total central committee members. So it does happen a lot. Representative Harshman. Representative Chadwick.
Thank you, Mr. Chairman. In answer to Representative Harshman's question. And I'm remembering this from roughly 3 years ago. The number was less than 50% are actually elected. So the rest of them are appointed. Now, Natrona County, it runs over 80% are elected. It's between 80 and 90. Elected.
80% are elected.
Over 80% are elected in Natrona County. Between 80 and 90, just depends on the year. And now, no, I said Natrona County. So that's just Natrona County. Now, and I know, if we're running somewhere less than 50%, that's not good. So it lends credence to maybe you're not getting the people's representation that you think you are.
Representative Haroldson?
Thank you, Mr. Chairman. I believe with the 110-day window that it would take to line up an election, one of the issues that a glaring obvious issue, I understand definitely the voice of the people concept, I agree with that, but there's a glaring obvious issue that for 110 days, you'll have a vacated office. Well, if that's right before sessions for a legislator, that's an entire legislative session without representation. If that is, that could be right into the middle of the federal government moving forward. I mean, we have to be careful, because if we're not careful, we eliminate our voice completely through that cycle. If we're not careful, I believe that this could definitely have some consequences as well.
Committee, you ready to vote on this? Roll call vote on House Bill 63, vacancies in elected office.
Representative Chadwick?
No.
Representative Haroldson?
No.
Representative Harshman?
Aye.
Vice Chairman Knapp?
No.
Representative Newsom?
Excused.
Excused. Representative Ottman?
No.
Representative Wiley?
No.
Representative Yin?
Aye.
Chairman Olson?
Aye.
3 aye, 5 no, 1 excused.
Okay. Next bill for our consideration is House Bill 49, municipal nonpartisan ranked choice elections. We do have to, gavel back in at 2:15. So we've got a good amount of time. We can at least get the bill introduced so that I know Representative Zwanser was still here to introduce the bill. We don't have to hold you over even if we have to take testimony in the next meeting.
Thank you, Mr. Chairman, and my apologies for not being here. Many of you know they canceled school today at 11 o'clock. After I solved that one, they decided to cancel community college at noon, so I had to go make some pickups and distributions. Happy to present House Bill 49, municipal nonpartisan ranked choice elections. And so just a little bit of history, and I'll try to be quick, Mr. Chairman. I don't think it's any secret. For about 10 years, your corporation's committee has been dealing with the issue of primary elections and whether or not the current process we have of winner take all is in fact the best way to conduct our elections. Every state gets to say how they conduct their elections, including their primaries. And so we have, as a committee, heard increasingly after the 2016 and then the 2018 gubernatorial election that there's many people in Wyoming who would like a different process for a primary election. I think the difficulty has been they all have different ideas of how they'd like that to look. So one of those many ideas that your former corporations committee has listened to hours of testimony on was ranked choice voting. And I'll go ahead and assume you all know what ranked choice voting is, or instant runoff voting. They're usually interchangeable, it's very small differences. But as we discussed and heard from many people talking about instant runoff or ranked choice, 2 states now utilize it, and probably over 40 cities throughout the country as a way to elect their leaders. And so throughout that conversation, we had multiple bills and ideas over the last 2 years. We did not make any change to state level law for our state elections or county elections, but we did discuss the possibility that if one of our cities wanted to engage in a ranked choice or instant runoff voting scenario, and as you know, we have 99 municipalities, many other smaller communities, and if they wanted to engage in this kind of RCV endeavor for them to select, their mayor, shall we say, and think of these at very small levels. I don't think a city my size would ever decide to do this, but in your 400-person cities or towns that have 3 people running for mayor, everybody knows everybody. Maybe this is the most fair system to do that election. And so your interim committee couldn't think of any reason why not to allow the flexibility if one of our municipalities wanted to conduct one of these at their own expense and their own cost. So no state funds. Basically enabling legislation that if any municipality wanted to use ranked choice or instant runoff voting as a way to elect their leaders, that we believe that was admirable and would allow them to do that. So that is what the bill does, Mr. Chairman. I can walk you through kind of the intricacies of what it means to have a recount. You'll see there's some weird percentages there. What it looks like with a canvassing board, but it basically just has that city or municipality telling the Secretary of State, we're going to engage in this process of voting and check with our county clerk. I'm not sure that's specifically spelled out, but it certainly has the Secretary of State ensure that municipality or their county kind of understands the city knows what they're doing and is going to conduct a proper election. I guess the only other thing I would mention, one of the reasons, the main reasons we didn't decide to move further at a state level with ranked choice voting is that our machines are not, they're federally certified, and right now the federal certification would be violated, like they do in Maine, to do ranked choice voting on those systems. And so we're not looking at this at a county-wide level or a state level, but if a city wants to do it, we said, go at it. Happy to answer any questions.
Representative Swanser, one of the things that I'm confused about is that this is a pilot, this is called the pilot program. But I can find when the pilot program starts, and that's January 1st, 2024. That's on page 5 of 22-23-1103. But is there like a sunset date in here? So well, how is it? Because that's how I would envision a pilot program, is that it goes for so much period of time and then it ends, and then we would have to take an affirmative action to continue it.
So, Mr. Chairman, and there probably wasn't the right language to use pilot program because these have never been done. I think the talk among the committee was, hey, we had the first draft, let's make it a pilot, pick a city or town to do this, have them do it, and then it looked like specific enabling legislation for one community. When we decided that it would really be at any community who wanted to do this at their own expense and nothing that the state would be paying for, we did kind of change that language, and I think we just forgot to take out the word pilot. So it's basically a pilot until some municipality actually does it, and then the belief was the committee would come back, corporations committee, and say, well, how did it go, and is it working?
Gotcha.
This is modeled after a law in Utah. I think they have almost like 25 of their smaller level municipalities engaging in this process. Heard good evidence that people were happy with it. The education barrier was low, and especially in a small level municipality, people figured it out pretty quick. There's some fear that ranked choice is going to be difficult for the voter to comprehend and have to number their selections. But the testimony was in these smaller level where everybody knows everybody towns, people got it real quick. So it's an unlimited pilot project until it is done, and then this committee would, see if it had good results or not.
And entirely permissive. That's the other thing about a pilot, is usually we pick the guinea pig, but here there is no guinea pig. The guinea pig is any municipality that chooses to opt into it.
Yeah, we had some difficulty, Mr. Chairman, on should we select someone, and then you don't want to just do that because they're mayor, they're city council, and as many of you know, all of our municipalities have different forms of local government, a strong mayor, weak mayor, council mayor system. And so we really said, hey, let each municipality decide. and we weren't going to specify. And as soon as we said, there's no state money going to help you with this is totally at your expense, then it probably shouldn't be called a pilot program. It should just be called enabling legislation, perhaps with a sunset in 10 years if anybody were to undertake this.
Okay. Representative Chadwick?
Thank you, Mr. Chairman. Mr. Zwanitzer, so could, you touched on the costs. Could you review those for us? And who bears that burden? How much are those costs? And I know they're substantial.
And certainly, Mr. Chairman, Representative Chadwick, it would depend on the municipality size, right? If we're talking one of our smaller towns, say Albin, in my county, 280 people, it burned 300 people. These aren't under the federally certified voting machines. And so it could not be expensive whatsoever above however they conduct their elections now. So if they decided they didn't want to elect the mayor of their town, so in my district, right, we elect our mayor alongside everybody else on the ballot. But in your smaller communities, they may have separate elections. So it might not, I don't believe, in depending on the size of that community, there's any extra administrative burden besides if there were multiple people running, somebody would have to, go through the proper procedures, hopefully in consultation with their county clerk is just one more set of eyes on that election. But it's how we do special district elections, now. Those very small level 20 ballots come in, shall we say. Our clerks do that, but they don't have to be the expensive statewide $1 million to have a statewide election that we have if it was a statewide election. So I don't anticipate any great cost above and beyond what it would already cost to conduct their election.
Representative Ottman?
Thank you, Mr. Chairman. Chairman Zwanitzer. So do you have any idea of the ones that chose to do this in Utah? Was there a minimum size, or do you know about what size? And also, if it's going to be opt-in, basically, because if some of our smaller municipalities and things like that may have 2 candidates.
Chairman Zwanitzer?
Mr. Chairman, Representative Ottman, I do believe there are people here to testify who have more specific direct knowledge of Utah and how these systems have worked. And it would be interesting if the community decided we want to take on this pilot project and then they only had 2 candidates. But I guess, depends who wants to run for office.
Thank you.
All right. Thank you, Chairman Zwanitzer. We have 15 minutes before we have to gavel back in. We're definitely going to be carrying this bill over to our next meeting. My question is there anyone in the room who's traveled here today that would not be available on Friday? Go ahead and raise your hand if you fall into that category, because I'm going to bring you up right now, if that's the case. Okay. No, then we'll just take public testimony as it comes. We have our clerks. I believe, are our clerks still in the room? Yep, come on up. Do you want to testify on this bill? Welcome back. This is the bill you tried to testify on earlier. Now you can actually testify on
I
it.
get a chance now, don't I?
Yeah.
Mr.
And
Chairman and
Just
committee?
remember, we only have now.
Keep it
15
short.
Yeah. Well, no. Just be cognizant of the time.
Mr. Chairman, I'm Mary Langford, and I have the honor of being here with Clerk Freeze from Fremont County and Clerk Bartlett from Carbon County. Today, we'd just like to visit a little bit about this bill. Our concern here is that, and we need to let you know that administratively, we are able to conduct this election. We're able to do ranked choice ballot and tabulate that. However, if we do that with our equipment in conjunction with a November election, which will also probably be a federal election, we have to have a third party do the ranked choice tabulation on those results for that race. And we'd have to lease equipment and software to be able to do that. That estimated cost is about $10,000. And so that there is a cost if we were to do that. Now, if there would be a scenario where we were doing a standalone election, and it was not on the federal ballot, then that could be a different situation. But we would anticipate that we're running it right along with everybody else that we would run in a general election.
So that's already a very interesting point on how this legislation is built, because there's no state funding. It's optional for a municipality. So, but the municipality could opt into it, but then the obligation for the cost and to carry out the election is going to fall on the county. No, it'll fall on the.
They'll pass it on to the town.
They'll pass
or
it
the
on to
city.
the town.
Yes, Mr. Chairman.
Okay. I
Yeah.
see. Go ahead.
Let's see. So, there's probably some additional cost for ballots. We wouldn't know that, but that's a small cost in comparison to the leasing of the equipment. As you also know, there's probably, to accommodate ranked choice, we'd probably need to have some modifications to WyoReg, the voter registration system, to be able to, take care of that new form of election, and training also that would be required. So our biggest concern here really is the cost of the leased equipment, plus the fact that the third-party certification is not there on the ranked choice, and that we would have security issues for our system to move something out to something from our hardened system to a not hard system, to an optional system. So, and that's basically it for us. Administratively, as I said, we can run the election, we can get results. It's just the issue with the leased equipment and the third-party contract
And the ballots.
and the ballots.
Committee, questions for our clerks? Yep. Oh, more information. Go ahead.
Julie Freeze, Fremont County Clerk, just to kind of solidify that. So it is not certified, the ranked choice voting in Wyoming. And that might not be a problem because a municipal election is not federal. So we don't, our systems have to be certified, federally certified when we're doing federal elections, right? But this all, as I'm reading it, ends up happening in the general election, which is now on a federal election. So that is a problem, or that makes us have to do a separate ballot, which I'm going to tell you again and again and again, anytime I see this, is very difficult for our voters to understand why they're getting two ballots. Plus more cost.
Representative Yin.
Mr. Chairman, thank you, clerks. On page 6, it says a county clerk or a municipal clerk of a participating municipality could conduct the race. What would that look like if the municipality conducted it?
Mr. Chairman, Representative Yen, I am not aware of any municipalities that have voting machines. Either they run them, they're small enough they can run them by paper ballot, is what my understanding is in the May elections. Most of the rest of them have joined our primary and general balloting process, which is the statewide system that we have. So for what this means to me is I would certify in Lander or Riverton, let's say one of those wanted to run it, I would certify that I could do it for them, but they're going to pay for it. That's all I'm going to certify to, is that I have the ability to do it for them.
So, Mr. Chairman, thank you. Does that mean, so a smaller town, if they didn't feel like the population warranted leasing machines and they decided to hand ballot it, they could do it themselves if they wanted to?
Mr. Chairman, Representative Yen, I'm not sure how you do that on paper. I guess maybe you can do it. I don't know. Never tried that. It's supposed to be a process, and I don't know how hard of a process is for a small community. I, first of all, can't imagine that they would try that in a small community, but I'm not sure how that works, to be honest.
Representative Ottman.
Thank you, Mr. Chairman. Clerk Freese, would it matter or be possible with voting centers to have this go on? I mean, is there any difference, or would it work the same?
Mr.
Clerk Freeze.
Chairman, Representative Ottman, Fremont County does have vote centers, why she's asking that question. No, it would not change anything that we do. A vote center just means that you can vote anywhere in our county, but it doesn't change the ballot, or how we count them.
Right, right. We do the same thing in Laramie County. We used to have designated voting centers based on your location, but you can go to any one of the voting centers now in Laramie County. Representative
follow-up.
Ottman?
Just for a point of clarity, so if a municipality, say one of the little communities decided, well, we want to do that, or smaller ones, the ballot could still be written and voted on, and it would just go out then for that. It's able to be differentiated.
Mr. Chairman, Representative Ottman, there is no change to that in a vote center. It's just that a person from Riverton could vote in DuBois if they happen to be there that day. They're going to get the same ballot. We just use the express vote for those situations, but still has the same ballot. And then it would go through this other machine or software to do the ranked choice voting. So it doesn't change anything just because we're vote centers.
Oh, and I'm not, excuse me, follow up. Not to say anything about the vote centers, just to say if a municipality, just say one of the northern one that's a little larger, decided to opt into this program and the rest of them didn't, the ballots would be the same and it could be counted all the same. It wouldn't make a mess.
Mr. Chairman, Representative Ottman, so we have 6 municipalities, so the other 5 would remain on our system probably through the primary and the general. And the other city or town would be only on the general, so they wouldn't vote in the primary. Again, it would be a little bit confusing for the county to have only one municipality on that, but that's the only difference, if that makes sense, for our other municipalities. And again, since I'm going to go ahead and say about the vote centers, it doesn't matter. So if it's DuBois that does that and nobody else does, but people are somewhere else voting, the DuBois ballot is only going to be on the general for those folks. They'll get everything else on the ballot, just not the municipalities. It will be the same. It won't change anything, trying to say, except where it'll be in the general, not in the primary for those folks.
Representative Chadwick?
Thank you, Mr. Chairman. So this being a may rather than a shall bill, so cities and towns may do this ranked choice. Could you give us a scenario where it might be advantageous for a city or town or maybe a district to do to go through this process?
So, Mr. Chairman, let's say in a primary election in a mayor's race, you have 5 people running. So you have more than the 2 or 3 that are going to go, and you double the amount that go to the general, right? So if you have a large amount of people running and you can't get to that 50%, which is what I keep hearing is why they want ranked choice, that might be a benefit to them if they continually have several people run and don't feel like they're getting the higher vote. That's what I heard during the interim for any office, is that we can't reach that 50% and feel like we really got the top people going on to the general. So that, I guess, would be where it might be advantageous for them to say, we do this all the time. We always have way more people running than we need to, and so let's just rank them and be done. And that's my guess. I mean, that's just from what I heard in the interim, so.
All right. Thank you.
Thank you.
Clerks. All right, it's 2:10. We only have 5 minutes left, so what I'll do is I'll just go ahead and unfortunately pause. I'm just going to pause public comment. I'm not cutting it off. We'll continue hearing House Bill 49 on Friday during our noon recess, as well as hopefully other legislation that we have assigned to our committee. So if you have signed up online to testify publicly, we'll see you on Friday. If you've arrived in the room to testify publicly, we'll see you on Friday.